Ready to go. Good afternoon, everyone, and thank you for joining us today. My name is Kevin McKeon. I'm the Deputy of Assessment Administration for the Pinellas County Property Appraiser. I'm here today representing Mr. Mike Twitty. And this public education session is understanding your notice of proposed property taxes. We will get into all the details, but next week you will receive your proposed property taxes for 2023. And we will go through everything you need to know about that mailing. It drops on Monday. Most of you will receive it on Wednesday. So we're going to go through first how your property taxes are determined. Value times rate equal taxes. We are responsible every year as of January 1 to value your property at market value. Your taxable value, which we'll get into, times the rate will equal the taxes you are required to pay. The taxing authorities are responsible for setting that rate. We are responsible for the value. So the first value we'll talk about is market value. Again, we appraise all or value all parcels of real estate in Pinellas County, and there's some 430,000 parcels annually every January 1. Okay.
Hear you, but it should be. Check real quick. Should be correct. Yeah.
Okay, can everybody hear me now? Those who couldn't before, would you please type in the chat that the sound is good? Yes. Okay, good. Thank you so much. I appreciate it. Thanks for letting us know. So I'll go back a little bit and okay, back to how taxes are determined. It's value times the rate. We determine the value at the property appraiser's office. Your taxing authorities determine the rate that is applied to that value. So we have the legal responsibility to look at all transactions in a given year that determined your value as of January 1. So if you were a purchaser in 22, January 1 of 23 sets your market value based on not only your sale, but sales of similar homes in your area. There are three approaches to value in appraisal: sales comparison, cost, and income approach. However, the one that is mostly relied upon for residential real estate is the sales comparison approach. We look at all sales of similar homes in your area to determine the value of your property. And we do that on a mass appraisal basis. We are not individually valuing everyone's home like an appraiser would if you go to get a mortgage, or when you bought your home, there was an appraisal report. We're not in fee appraisal. We do mass appraisal because there are so many parcels that we have to do on an annual basis. So there are three values that we use, and we will get to those values and show you where they are on your notice of proposed property taxes with regard to determining your taxes. There's the just market value. So if you were a brand new purchaser in 22, your value as of 23 will be a new market value based on comparable sales of similar homes as well as yours. And typically, unless you are a previous Florida homesteader, your market value will equal assessed value at that time. And if you have already applied for homestead, you will then have, or any other exemption, those exemptions will be deducted from assessed value to determine your taxable value. Taxable value times rate will equal your taxes. So the taxing authority has jurisdiction over the determination of and collection of property taxes. Again, we come up with the value, they come up with the rate. Rate times value equal taxes. Now, there are 56 different taxing authorities in Pinellas County. Some are county related, some are city related. There are 24 different municipalities. So depending on the city you live, they will have a rate applied to your value. The county's general fund, which provides a lot of the services for the county, has a rate applied to their value. And we'll get into the detail of some of the common taxing authority rates when we get the notice of proposed property tax example up. So the taxing authority has already determined, as of today, the rate that they propose be applied to your value to determine your individual taxes. However, they have not yet held public meetings with regard to you being able to attend a public meeting to listen to their reasoning behind the value they chose and comment on whether you think that value is fair or not. We will get into all the detail of each one of those authorities, when the meetings are, and when and you are eligible to attend any and all of them. As a taxpayer, that is your right. So your appeal to value, as far as the millage rate is concerned, is with the taxing authorities. Your appeal to value as far as market value or assessed value or taxable value, you deal with our office. So a mill is a unit of measure. Now a millage rate is applied by the taxing authorities to the value to the taxable value we have on your property. So simply put, 1 mill represents $1 for every $1,000 of taxable value. So and we'll get into all the different millage rates that are on a typical notice of proposed property taxes. So taxable value times the millage rate will equal your ad valorem taxes. That will be the taxes that you are responsible to pay for 2023. And to go a little bit into when they are due, tax bills will be sent out by the tax collector. They are actually mailed on October 31st. You should receive those bills either the 1st or the 2nd. If you have a mortgage, your mortgage holder will also receive a copy of that bill, and they will pay it in November to let you have the maximum discount. November, there is a 4% discount if you pay your taxes in November, and we'll get into that a little bit more. So if your home is worth $100,000 or the taxable value times 20 mills, your taxes would be $2,000 for the current year. And again, the current year is 2023. Your taxes are paid in arrears. So in November, you are paying a bill for all of calendar 2023, even though the first bill is in November. You may live in a taxing district that has special assessments. Okay, these are called non-ad valorem taxes as they are not related to value. They are established by a taxing district, not based on value, but typically set based on so much per household. And it's usually for stormwater, utility underground, street lighting, et cetera, et cetera. That is in addition to your ad valorem taxes. Not everybody has them. It will appear on your notice of proposed property taxes. We put it on the notice of proposed as a courtesy, so you can see your total taxes that will be due. We are not responsible for determining the amount of non-ad valorem taxes, but there's contact information with regard to those that you can call and find out information. And we have a question from the audience. Yes, sir.
Quick question. So non-ad valorem, do those ever fall off or are they usually pretty?
They potentially fall off. It depends. Oh, I'm sorry. The question was, do non-ad valorem taxes fall off? In a lot of cases, what happens to assess a non-ad valorem, the taxing authority issues a bond. Okay, that bond pays for all the improvements, and that bond is paid over time with everybody getting assessed a little bit. Okay, some do fall off. Yes, some do not. Some are very temporary. Some are one time. So it's they're all a little bit different. But if you do have non-ad on your bill, you can call. We have a contact number for that non-ad, and you can find out if that will ever fall off. Okay, great question. Thank you. So here we get into exemptions. Okay. The most important thing to do if your property is your primary household and you own and occupy as of a January 1 is apply for homestead, because that is a reduction. It's a discount, so to speak, on your property taxes. And that sets your value after the first year you are eligible for homestead. That then sets your value for future years, whereby your ad valorem taxes can't increase more than 3%. Excuse me, your value can't increase more than 3% as far as your assessed value. And we'll get into that a little bit. There are a myriad of other exemptions that are available to you in the state of Florida. Most of them relate to being a senior over 65, being a widower or widower, having a disability, whether it be a military veteran service related disability or a disability of some sort. Our office is available at any time to answer any questions with regard to your eligibility. But again, most relate to being a veteran of an armed services of the United States, being over 65, or being disabled, or a widower. Why apply for homestead? Well, $50,000 off your assessed value in most taxing districts is worth between $800 and $900 reduction a year in your taxes. So it's significant. Okay, it's very helpful, and it sets the bar for future years, which we'll get into. Now, that $50,000 is in two different bands. Okay, the first band is if 0 to 25,000 worth of assessed value is exempt totally from taxes. The next 25,000 is not exempt from taxes, and the value between 50 and 75 is exempt from taxes. So if your assessed value is over 75,000, you're going to get the full $50,000 exemption. If it's between 50 and 75, you get the first 25 and then that portion between 50 and 75. So sometimes you look and say, I thought it was a $50,000 exemption. That depends, all depends on your assessed value. And that second 25,000 is not an exemption for school taxes. So you will see on your trim notice that your school taxes only have a $25,000 exemption, not a $50,000 exemption. Obviously, anything over 75, there is no homestead exemption. So save our homes. Okay, this is after you have established homestead. We'll give you an example of what could happen. And here's a wonderful example. When these notices of proposed property taxes come out, neighbors like to talk to one another and say, oh, what are your taxes? Oh, what are your taxes? Well, that depends on how long you've been in your household. Okay. The house on the right in this illustration, the homeowner bought it in 1993. So they have had the benefit of home ownership and a homestead exemption since 1993, meaning every year after that, they only went up in assessed value by consumer price index or 3%, whichever is lower. So, and we had a downturn back in the 2000s. So their value went way down and now it's coming back up. This happens to be a very hot neighborhood in St. Petersburg, Florida. The house on the left was bought in 2020 at a price significantly higher than the person who bought it in 1993, obviously. So the house on the left, exact same size, exact same lot size, is paying $4,700 or plus in taxes. The one on the right, $767. Now, that doesn't seem quite fair, but that is the state law. Once you've established your homestead, you get the benefit of having that homestead with future value increases being limited. And why was that done? Back in 1992, Lee County property appraiser introduced this concept of a Save Our Home cap because longtime Florida homesteaders, that was a run-up of value back then, were being taxed out of their homes. There was no limit on how high your taxes could go. So they introduced this. You know, typically real estate and residential real estate is a nice steady 2 or 3% increase every year. Well, we haven't seen that in a long time. We've seen a great run up in the early 2000s, a drop back down, and now a run up since 08 that is quite unprecedented in our county. So it creates some disparity between a new homeowner who just established homestead, because your market value equals your assessed value that first January 1, if you're brand new to Florida. And you can see how a long-term homesteader, okay, this is the assessed value. This is the history over the last 14 years of CPI and the 3% cap. Only 3 times in the last 14 years have we hit the 3% cap. You look at those lean years and in 12, 13, 14, 15, 16, your assessed value was going up in some years less than 1%, yet market value was rising. So you're not paying taxes on that difference between market and assessed, okay? And in 2008, if there was also a problem in Florida with non-homesteaded commercial real estate. They were getting priced out because there was, again, the run up in 3, 4, 5, 6. Everybody, wait a minute, we can't afford to pay property taxes on our little beach motel or our restaurant or our strip center that we've owned for quite some time, because there was no limit on that. what the legislature did in '08 is institute a 10% cap on non-homesteaded property. So there are two caps. There's a homestead cap, maximum of 3%, and there's a non-homestead cap if you're not homesteaded, maximum of 10%. However, on the non-homestead cap of 10% per year, similar to the exemption on homesteaded property, school taxes don't have that 10% cap. So you're paying full school taxes on market value of your property, which is in some cases about a third of your tax bill is our school taxes. So here's a quick example of how Save Our Homes works. Okay. So let's say you bought, and I'm guessing most people who are joining us online today or here in our audience bought in 22 or 23, and they're trying to figure out, okay, what's going to happen to my taxes in the future? So if you bought in 22, you will see that your value, come January 1 of 23, your market value will equal your assessed value. Okay, if you're brand new to Florida, it's a reset of market value, partially based on your purchase price, partially based on the average purchase price of similar homes in your area. Okay. Every year after that, once you file for homestead, so 24 and after, that assessed value can only go up by CPI or 3%, whichever is lower, the maximum of 3%. So over the years, you start developing that gap, okay, of the difference between just market value and assessed value, which you're not paying taxes on because you've homesteaded that property. So at the end of year 7, you have $43,000, the difference between market and assessed. And this is a very simple example of market going up 5%, assessed going up 3%. You have $44,000 roughly of that differential that you're not paying taxes on because you're a longtime homesteader. It's the benefit of being a longtime homesteader and having a homestead exemption in Florida. That difference is called your Save Our Homes benefit. Now, again, into the 10% cap. I talked a little bit about this already. I jumped ahead of myself. So again, you have a 10% cap if you don't happen to be homesteaded or you own a piece of commercial property that can't be homesteaded, but the full market value is taxed with the school millage. And that cap remains similar to your home as long as ownership doesn't change. Homestead exemption is not applied for. This is an issue as well. Let's say you had a vacation home that you have owned in Florida since 2015, and you decide to finally, and you had an exemption in another state. Let's pick Illinois, which made you ineligible to have homestead exemption here in Florida because you can only have one. You were subject to that 10% cap on your vacation home here in Florida. You decided to retire, come down to Florida and apply for homestead. You sold your home in Illinois. Unfortunately, state statutes require at that time, when you initially apply for homestead, your property goes to market value as well. Your market will equal your assessed. A little unfair since you've been paying taxes all along, but that is the statute we have to abide by. And sometimes, depending on that cap that you lost, or with the 10% cap, you're better off not having homestead. And because a $50,000 exemption is worth $800 to $900, you may lose a $200,000 or $300,000 or $400,000 cap in that initial year to get you that exemption. So, but our office is more than happy to walk you through that process as to the difference between having homestead and non-homestead if you're in this situation. And we will have, and then it would be your choice whether you want to have homestead for the current year or not. Okay, now we'll get into the notice of proposed property taxes. Again, this is dropped in the mail on Monday, August 21st. Most people will receive it by Wednesday. Some people get it on Tuesday, depending on the mail. But this is the most important document you will get from our office on an annual basis. We are responsible for mailing the trim notice. And then in January, we mail out a renewal notice if you have homestead, just to let you know your homestead is automatically renewed unless something has changed in your life. You got married, there was a death of one of the homesteaders, you're renting your property, et cetera, et cetera. That's up to you to tell us. But once you establish homestead, there's really nothing you have to do in the future. You don't have to reapply. You just have to abide by the rules of homestead. And, but we refer to it as a trim notice. Now, what that stands for is truth in millage. Okay. But, you know, that's just an internal acronym that we use. But the notice of proposed, you will get this come next week. The first thing you're going to look at, I can guarantee you, it says, do not pay, this is not a bill. And then you'll throw it in the trash. I urge you not to do that, please, because this has a wealth of information on it for you to determine. So the top part is very simple. It's got your parcel number. It's got your last name, first name, address. It's got your taxing district, your site address. So make sure all that is correct. Okay, now, if there are 2 or 3 or 4 owners on a property, we can't print them all. There's not enough space on the trim notice to print them all. We usually print the top 2. And but if you have any questions, please call our office. We expect you to. The next section is the most important section to look at for your purposes. We show values from 22 and 23. In this particular example, this is a homesteader, okay, because the 70,156 in assessed value only went up by 3%, okay? And they have a homestead exemption and maybe some other exemption because the taxable value of 25,000 is more than 50, is a little less than 50,000, 71,629. Remember I said earlier, you get an exemption on that second piece of 50 to 75. If your assessed value is less than 75, you only get a portion of that second 25. Okay, and then there are a county taxable value, school districts, because remember that first 25,000, not an exemption for school, excuse me, the second 25,000, and then municipal. There could be some senior exemptions or other exemptions that are. So these taxable values then get dropped into the form below. Okay. Column 1 is last year. Okay. Column 2 is a state requirement that we have to disclose to you, which is called the rollback rate. What that means is each taxing district has to compute a rate they would charge you for 2023 if in fact they collected the same tax dollars in their entire district as they did the year before. So values went up, they're going to collect more taxes, and they have to disclose the rollback rate. That is very rarely the rate that is determined to apply to your value. So if you look in column 2, in the first column taxable value, those taxable values in the blue on the previous slide get dropped in here, okay, into each one of these taxing districts. 25,000 for the county. You see the school is a little bit more. You see the municipal is 0 because they probably have a senior exemption applied to that municipal taxes. And then that times the first column in column 3, which is in yellow, the millage rate. Those are the proposed millage rates that each one of those taxing districts has set for 2023, subject to their final budget hearings, which are each one has as the initial budget hearing coming up soon, which I will get to in a minute. So you take the taxable value times the millage rate equals the taxes. That particular property, the taxes actually went down from 22 to 23, but they have a non-ad valorem tax as well, which is the same as it was the year before. So, and then down below, you will see the exemptions that they have and the Save Our Homes cap. So we had the Save Our Homes cap went up a little bit from 22 to 23, and they have the homestead exemption, first and second 25, of which they only got a portion of the second 25. And they have a limited income senior exemption, which is an additional exemption off the city or county or the unincorporated county millage rate only. There's only one line that applies to, and that is municipal service. In this case, if you're in St. Pete, that would say St. Petersburg. If you're in Clearwater, that would say Clearwater. This happens to be unincorporated county. That additional 25 brings their taxable value to 0. So they're not paying any municipal taxes, so to speak. Now, down at the bottom in yellow, everything in yellow is important. That's if you haven't figured that out by now. You have an opportunity. If you don't like the value on your that we have placed on your property for 2023, if this is a brand new homestead and we just put a new value on it and market equals assessed, you have an opportunity to file what is called a value adjustment board petition. You can file a petition at the clerk of the court. It's $15 to file that petition, and you can come in and attest, object to the value that we put on your property. It is a very informal hearing. There is an independent person, and if it regard to value, it is an appraiser, okay, who is familiar with property values in Pinellas County. The appraiser magistrate listens to your side as to why you should be valued at X, listens to our side as to why we valued it at Y, and they make an independent determination as to who's right. Before you do that, you can call our office, okay, and talk to the area appraiser, which I highly recommend. And you can talk through why we valued your property, what we did. You have that opportunity as a taxpayer. That is your right. So I encourage you, if you feel that your value is not what you think it should be, most people don't think it's too low. It's only when you think it's too high, to call our office. The telephone number is 727-464-3207. We can direct you to the appraiser who is responsible for your area. And you can talk to them. If you're not satisfied after that, then you can file a VAB petition. But you only have until September 15th to file that VAB petition. After that, it's up to the clerk of the court whether to determine whether you had just cause to file late for a VAB. So you only have until that date. And going back, if I can, to the top part, let's say you're a brand new homesteader and your market value equals assessed value in 2023, and you look at this and the taxable value also equals assessed value, that means you don't have a homestead exemption. You may think you filed. You may have been told by your title company that, oh, don't worry, it just transfers from your last house. We need to have an application, okay? Nothing transfers, because when you buy a new property, all we have is a legal description and your name. We know nothing about you until you file for homestead. And that way we have all your information and to make sure you're eligible for homestead. So if you see that your taxable value equals your assessed value, you still have time to file for homestead. And that time is the exact same date, September 15th. Beyond that, state statute says we cannot grant an exemption for 2023. You have lost your window. So although we have a deadline, a state imposed deadline of March 1st to file for homestead exemption if you bought in 22, that's extended to September 15th with extenuating circumstances. You fill out a form, you tell us why you didn't file on time. It's never really denied. And if you meet the qualifications, we can still grant your homestead exemption up to and including midnight, September 15th. If you wake up Saturday morning and say, oh, forgot, I'm going to go online on September 16th, you're out of luck. You have to wait till 2024. So please get in touch with us. And if you have forgotten to file, or if you haven't filed yet, we want you to get as many exemptions as you're entitled to. And if you're eligible, we'll be happy to take care of you and get that homestead exemption in, because again, that sets the value for 23 and 24. You're subject to this save our homes cap. You're not subject to, yes, sir, question.
So on that point, let's say you bought a property before 2022, let's say 2020, 2021, and you didn't, the value went up significantly and you didn't appeal that amount.
Okay.
And then now that value was basically set in.
Okay.
Can you appeal it after that
Okay.
first year?
That's a very good question. The question from the audience was, let's say you bought a home in 2021 and you have not filed for homestead and the value has skyrocketed now all of a sudden you're in 2023. You woke up and realized you didn't apply for homestead, so you didn't get the benefit of the Save Our Homes cap. Can you appeal a prior year value increase? The answer is no. You have a window in your current year to appeal a value. If you don't appeal it, then you've lost that window. You can only appeal a value, or you can also appeal. Let's say we didn't grant your exemption because there is certain information in your application that we feel disqualified you. One of the perfect examples is you're married, okay? Only you applied. Your spouse didn't apply. Guess what? We cannot grant your homestead exemption. Even if your spouse isn't on the deed, it doesn't matter, because a married couple is only entitled to one homestead. Your spouse could have a homestead somewhere else, but we don't know anything about them yet. So we have to get their social, their date of birth. We have to make sure that they're eligible, even if they're not on the deed. So if you said, I don't care, I'm not giving you my spouse's information, well, that's fine. You don't get a homestead exemption. Again, that's state law, but that's one of the examples. But if eventually you acquiesced and said, okay, I'll give you my spouse's information, we will, because you filed a timely application. We don't like to do it, but we will go back in time and do a tax correction for you. But values and lack of exemption in a particular year, you can't go back. So if you want to look at 2022 today, you've lost that window of opportunity, or any prior year beyond that. Now, you always have the option of going to circuit court and suing us, but that gets a little expensive. But that is an opportunity that avails itself to you as well. Yes, sir. One more question.
One more follow-up on that. And you may not know this answer, but in terms of people who do appeal their values, do you have an idea on how many are successful, a percentage roughly?
Two different cases. Okay, let's talk exemptions. Okay, an exemption, you go before a lawyer in a magistrate hearing because an exemption is an interpretation of the law. It's not a value issue. Very rarely will you win an exemption appeal because we go out of our way to try to get you qualified for an exemption you're eligible for. But if it just doesn't line up with the statutes, so I would say your chances of an exemption appeal are relatively small. Value, we get about, and I'm throwing out some numbers, 1,300 petitions annually. Okay, both commercial property, non-homesteaded property. Most of those are settled before you go to VAB hearing. Either you decide, okay, the appraiser's right. I'm not going to show up for a VAB hearing because I have no chance of getting my value reduced. So I'll withdraw my petition and agree to the value. Or you talk to the appraiser and say, wait a minute, you've got a shed on there and I never had a shed on this property. And you come to a meeting of the mind, what we call a meeting of the minds, where there is a slight reduction in value without you going to VAB. Now, that's not all of them, but maybe 30% of those, 25 go to a VAB hearing. We don't lose that many, okay? But because we feel we're fairly valuing your property, we have a ton of information. We have all the comparable sales. Now, we've never been inside your home, okay? But in that meeting of the minds process, if you want to invite the appraiser to look at the inside of your home and maybe there was some damage that we didn't know about that you want to point to us, we're happy to take a look at it. But in most cases, people don't invite us into their home. But it's worth it if you believe you can get a reduction in value. And sometimes that's more than likely settled before you even go to a VAB hearing. And because when you go to a VAB hearing, you have to submit your evidence. We have to submit our evidence. We get to see each other's evidence in advance. So, I mean, it's a great process that affords the property owner that opportunity. And so if in fact you feel you've been slighted, feel free. We want you to avail yourself of that opportunity. So on the back of the notice of proposed property taxes is the budget hearings. So these don't happen to have dates and times and addresses, but your trim notice will have it. So each one of those budget hearings are held at different times. So you can avail yourself, if you so choose, to attend all the budget hearings and voice your objection to the millage rate proposed. Okay. I believe the county's is September 9th is the county's budget hearing, and that is comprised of those first four different taxing districts. And then there's the school board. This one, Tarpon Springs, has their own, et cetera, et cetera. All these districts have budget hearings that you can attend and talk to the authorities who are responsible for approving the millage rates. And I encourage you to do so. Now, I attend as a member of the property appraiser's office, the county budget hearing every year. Maybe one or two people show up. But there are instances where it's legitimate that they show up, and I can meet with them outside of that meeting and explain to them, because maybe they really have a value issue and they showed up at the budget hearing. Well, the time that the person to talk to would be our office, not the county commissioners or the city council. Now, If there is a non-ad valorem tax, the levying authority, contact name and number, contact number will be on there, so you can call them directly. We put non-ad valorem on the notice of proposed taxes as a courtesy to the non-ad. We have nothing to do with those amounts. And it's not subject to anything with regard to value or exemptions. There's just, again, on the back, there's a lot more information as to each one of the columns, column 1, column 2, column 3, and what they mean, what they do. And then we talk a little bit about market value, assessed value, taxable value, and what that means. So if you get that trim notice and you see, whoop, this is telling you that trim notice is available on the website. You put in your address, you put in your name, you go over to tools, you check trim notice, and you can pull down a copy of yourself if you happen to look at it and throw it in the trash by mistake. All trim notices will be on the website next week for each and every property. Right now, your values for 2023 are on the website. They're just not times all the millage rates to determine your taxes. But next week, you'll be able to see that both in paper and on the website. Okay, to wrap up, there's just a few more tidbits of information about our office. Again, I have what you will receive next week. I'm holding up for purposes is a trim notice. It's going to look exactly like this. Okay, front and back. It's a one-page document, and with it comes a friendly informational supplement that reminds you still have time to apply for exemptions between now and September 15th. And if you see where your assessed value equals your taxable value and you thought you had an exemption and you don't, you still have time. So please do come in. We don't want to see you miss that window of opportunity. We have all kinds of interesting tips available on our website. You can be accessed from www.pcpao.gov. Buying a home, selling a home, and portability. There's all kinds of great information for you. Is if you plan on selling, you have and buying another home, you have that portability opportunity. One thing we didn't really talk about, if you remember that slide that showed your buildup of the $44,000 over that 7-year period, you can take that with you to another home. We do that automatically for you. We ask you the prior homesteaded home, the current, obviously you're applying for homestead on a new home. You had a prior homesteaded home. We can move that differential to the other home. You get to take that with you. That's something that came into law also in 2008, subject to a maximum of $500,000. Okay. And it depends on whether you upsize or downsize, whether you get the full amount. But if you're applying on a new home and you have had a previously homesteaded property within the last 3 January 1s in the state of Florida, online, if you visit our office, we will ask you that. We will know that. If you go online, there's a section of the application that says, do you want to apply for portability? Please do. If you don't, we will remind you, but because we want to see you not lose that benefit. Yes, sir. Question.
With portability, does that only apply if you're buying property within Florida, or does that go to other states?
Within Florida only. Okay, so you can sell a home in Escambia County in the Panhandle and buy one here. You can port from there to here, but you can't. No other state is going to allow that to cross state lines. But you have that opportunity. And please avail yourself of that and don't lose it. Yes.
So if you keep moving.
Yes, as long as it's all within the state of Florida. But remember, depending on whether you're upsizing or downsizing and how much of a cap you have, you could be losing some of it, and you're subject to the market value of the January 1 after you buy to determine the amount of portability that you get. So in a rising market, you may lose some portability, or you wouldn't lose. In a falling market, you may lose some portability because that calculation is just value of new home after January 1 over just value of old home the year you sold. And by the way, that's not the sales price. Everybody thinks it should be the sales price. It's the value that that particular county had on that property as of January 1 in the year you sold. That ratio times that differential is your portability. Yes,
Is there a timeline that you have to buy and set it?
Yes.
Is there any?
good question. The timeline is 3 January 1s can pass before you lose your portability. So the first January 1, let's say you sold in 2023. And you haven't decided where you want to live, you haven't decided what you want to do, you're renting for a while. 1/1/23 is the first January 1, the year you sold. Then 24, then 25. That's 3 January 1s that have passed. If you don't establish Homestead by 1/1 of 26, you've lost your portability. So we get a lot of port questions, and those are all great questions. It's a little confusing, but it's a great benefit to those staying within the state of Florida, especially if you're a longtime homesteader getting ready to retire. You want to get rid of that big home and downsize to a much smaller home. The kids are gone. You want 1 story versus 2 because you can't climb the stairs anymore. It's an opportunity to take a lot of that with you. Okay, we also have an opportunity for you to follow us. We're on Facebook and YouTube. We have newsletters that you can sign up for. Homeowners, real estate professionals, business owners, we encourage you to do so. And also attend one of our public education sessions. Upcoming sessions in the future will be website tools and navigation, first-time Florida homeowners and real estate professionals. Please keep checking our website, www.pcpao.gov, to look for these sessions and a lot of other information, including this video, right? This video will be on the website that you can go back and view it. And if you have any questions, even after viewing it, again, call our office. We're happy to help you. We're here to educate you and help you understand and benefit from as many exemptions as possible. So that is our job, to serve you. One of the great free services that you can avail yourself of, available at the clerk of the court. Maybe a lot of you have read recently, there's some deed fraud going on out there where people somehow file a deed and try to get ownership of your property without your knowledge. The clerk of the court has a free website, and it's right here. There's a phone number, there's a URL that you can register yourself and your property. So if anything is filed at the clerk of the court in Pinellas County in a name that's anything close to your name, you will get an alert on your cell phone. Go look at this. Okay. So there's a lot of things that are filed at the clerk of the court besides just deeds. There's commencement of work. If you have a permit over a certain value, whoever's doing that work has to file commencement of work with. So I signed up for this, and I've maybe gotten 2 or 3 alerts over the last 5 years. My name is Kevin J. McKeon. I got an alert for a Kevin P. McKeon, just in case. Okay. So I can go look at that and see what was filed. Okay, that doesn't relate to me. it's comforting to know it's a free service. It's, you should avail yourself of that. So with that, we thank you for your attention and your great questions. We appreciate you joining us today. Hopefully it was beneficial to you, and happy to answer any final questions before we sign off, if there are any. Hearing none from the audience and none from those online, thank you so much. We appreciate it. Have a great day.